Last wills and testaments. Let's talk about how they work, how you get one, how much does it cost to get one, and what to do next. What is a last will and testament? A last will and testament is a legal document used to provide for one's wishes regarding the distribution of their property and, if applicable, for the care of minor children. Can you create a will without an attorney? That's one of my favorite questions. And yes, Oklahoma law does recognize handwritten wills, also called a holographic will. Or you have seen probably many ads on Facebook or on the other websites you visit about free or very cheap, very inexpensive ways to create your own will. I have to warn you though, for a will to be valid, it has to comply with the current law, and there are many requirements that you have to meet before that will be considered valid. An invalid or incomplete will cost you and your family a lot more money and time than you saved by going through one of these avenues. So what is included in a will? A will starts with some basic information. It has your name, you intend to create this will, and then it has your family information. You are married, you are single, this is my wife, we have 3 kids, I have 2 kids from a previous marriage, whatever the situation may be. Then it goes into specific or general gifts. I leave my car to my daughter, I leave my coin collection to my grandson, and so on. And then it has a residuary maybe, where it says whatever is left over is to be divided between my 2 kids or is to go to my spouse. It has a personal representative designation and powers. I nominate so-and-so to serve as my personal representative, and he or she shall have the powers as usually as allowed by the law. It covers taxes and final expenses, funeral arrangements, and a contest clause. If anyone tries to contest this will, they risk to lose their share or something like that, to provide an incentive for your kids or your beneficiaries to not contest your will. So what do you do with the will? Ideally, you store it in a safe location, but also in a place where it can be found. So many people have safety deposit boxes that nobody knows about, and it's really hard to find that will. You may also want to tell your personal representative that, hey, I have a will. Maybe not give them a copy if you're not comfortable, but at least tell them you have one and where to find it when the time comes. You do not have to tell your family about it, but if you do and discuss the terms of your will, it increases the chances that your family will accept your wishes and they're not going to try and contest it or to claim that it is not valid or made under duress or something similar. You do not have to file it or record it with the courts. That's a question that I get all the time, but you do have the option. Just have in mind that once you deposit it with the county clerk, for example, in the land records, it becomes public document and anyone can pull it off the internet. What happens to the will after I die? Well, probate might be needed, and probate is usually triggered by real property. So if you die owning real property to your name only, it will likely have to be probated and the will has to be filed with the courts. Probate is very lengthy, expensive, and a public legal process. You do not want to go through probate. You do not want your family to go through probate. So you may want to plan otherwise. We'll talk about that towards the end. But why does the will have to be probated? Because the courts have to validate it. They have to make sure it complies with the rules, as we talked about at the beginning, and also that the people have the opportunity to come and say, hey, that's not the latest will, here is the newest one, or it was made under duress, or whatever the situation may be. Through probate, creditors get paid first, and then whatever is left over will be distributed according to your wishes if you have a valid will. What about if you have a will? What else do you need? Well, a will does not provide for incapacity planning. What does that mean? A will does not cover the circumstance that you may become unable to make decisions and you need help with paying the bills or filing your taxes or making medical decisions. So if you don't have a power of attorney in place, A will is not enough to cover your incapacity, and likely an adult guardianship proceeding will have to be filed, which is very similar to the probate process, expensive and time consuming. Financial assets planning. A will may say, I want my car, my house, my bank accounts to go to your beneficiaries, but you may want to discuss your other financial assets. How would your pension plan go? You may have a life insurance, you may have some investments. A will does not cover that. You probably need to sit down either with a financial advisor to help you with that, or with an estate planning attorney. Probate. As we talked about, a will does not avoid probate, but there are other instruments. If all you have a home and one child, or in limited circumstances, you don't need a fancy estate plan. Or you may need is a transfer on death deed, or sometimes, but I do not recommend people use joint tenancy, as in adding a child to a deed. Not a good idea. That child is now half owner. How much does it all cost? Well, with our firm at Unity Legal Services, just a will starts at $250. Our will packages that include a will, power of attorneys, one healthcare and one financial, an advance directive or living will, and a brief consultation on your other assets starts at $500 for a single person and $1,000 for a couple. Our revocable trust package that would help you avoid probate, provide for a gradual distribution for your beneficiaries, or if you have, let's say, a special need beneficiary, includes the will package. So everything that the will package includes: the will, power of attorneys, advance directive, a simple revocable trust, the deed to your property into the trust, a detailed consultation on your other assets such as your life insurance, pensions, investment, stocks, and so on. Starts at $2,000 for a single person and at $2,500 for a couple. So what can you do next? Give us a call at 405-857-8231 to schedule an appointment or to ask any questions you may have. We will send you a brief intake form just to get to know you a little more and to help you get organized for our visit. We'll meet to discuss your needs and maybe review and sign documents if all you need is a will. And then schedule future appointments as needed. Usually for a trust package, we will meet probably 2 or 3 times before the process is complete. Thank you for watching.